Hi, I'm Lois Beasley-Carlisle again with bankruptcy tips. A lot of people ask me what is the difference in a Chapter 7 and a Chapter 13. Well, there's the main basic difference. A Chapter 7, you wipe out the debt that you no longer want to pay, you keep the assets that you want to keep, and that the creditors will let you keep. In a 13, you pay for part or all of your debts in a payment plan. Now, you will see on attorney's letterhead a lot of times something that says we are a debt relief agency. That just means that we help people file for bankruptcy relief under the bankruptcy code. Now, when you file bankruptcy, there's all kind of choices. You can have the court mail you your paperwork or email your paperwork. It's going to be automatically mailed unless you take the email election. If you want to take the email election, then you're going to have to ask the attorney to help you do that. Now, attorneys, how do they charge for bankruptcies? Well, attorneys are going to charge a flat fee or a retainer fee and a fee by the hour or a flat fee set by the bankruptcy court. And then it depends on whether they're going to handle a lawsuit for you within the bankruptcy court or just handle the filing of the bankruptcy itself. Part of the attorney fee is paid through the trustee when you're in a Chapter 13. So generally the same amount of attorney fee is going to be basically awarded to any attorney that files at 13, and it's going to be based upon, in part, your financial situation and the amount of debt that you owe. Now, what is the attorney going to do for me for that money? You're going to answer a bunch of questions. The attorney is going to put it in paperwork format that's appropriate for the filing with the bankruptcy court. The attorney is going to represent you at the court meetings and tell you which court meetings to go to and which court meetings you don't have to go to. And then if you come in and you see that there's a claim wrong, the attorney will help you file an objection to the claim. The attorney might help you file a motion to value the claim. If the claim is, say it's a car and it's worth $10,000, but you owe the creditor $20,000. Well, the attorney may help you strip down the lien to where you only owe the $10,000 on the car that you're paying interest for, and then you may pay pennies on the dollar on the rest of the $10,000. Again, the attorney is going to have to analyze your debts and your income and your assets to figure out what you have to pay back to the bankruptcy court. Now, again, a Chapter 7 bankruptcy can eliminate all your debt. If you just want to walk away and not owe anybody, then you can file a Chapter 7 if you otherwise qualify. You can make too much money. You can't have too much debt. You can't have too many assets to file a Chapter 7 bankruptcy. There's thresholds. Same with a Chapter 13. Sometimes companies have to go into something called a Chapter 11, but for our purposes, we're not going to get into that. We're going to assume this is talking about consumer Chapter 7 or consumer Chapter 13. Again, an individual can owe so much debt that he's not qualified for a Chapter 13. A Chapter 13 is also called debtor's court, and you can pay all or part of your debt back to your creditors depending on what you can afford after you take out your normal living expenses, such as your food, your car insurance, your health insurance, your power, water, gas, that type of thing. Sometimes if you can't pay all your debt back, you have to make choices and give things up. If you're paying less than 70 cents on the dollar to your creditors in a debtor's court, then that has the same effects as if you filed a Chapter 7 bankruptcy. An attorney cannot, over the telephone, give you advice on what kind of bankruptcy you can file, because there are things that you're not going to think to tell the attorney until you sit down and answer all the questions. And you're talking 40 to 60 pages of questions. There's no way that you can see why an attorney cannot give you those answers over the telephone. Sometimes they can't even tell you if you're going to be qualified to file a bankruptcy till you sit down and do the paperwork. Now, an AP is an adversarial proceeding. You might file an AP against someone. Somebody might file an AP against you. There are APs that we filed against creditors for interest violations. There are APs that, for example, I just filed an AP for a spouse or an ex-spouse in a domestic situation where the spouse was trying to bankrupt on the child support, and the theory was that it was a property settlement, and the way that it was written up was kind of iffy, so we filed a adversary proceeding to have that debt declared non-dischargeable. A creditor can file an AP against you saying that you've created fraud, like you falsified legal documents, you took out too much debt right before filing bankruptcy. For example, this one lady walked in and she had charged up $14,000 on credit cards like a week before she came in to see me, and I told her, I'm not filing a bankruptcy for you. And so she left. She might have got somebody else to do it for her, but that was several APs waiting to happen. She had gone and maxed out all her credit cards and then figured she'd file bankruptcy. You have to use some common sense. Of course, AP's attorneys might charge you additional money for it because it takes additional work. Sometimes the things that attorneys can sue for are fee shifting violations. Maybe there's something a creditor's done, and in the lawsuit, the attorney can shift the fees to the creditor, and the creditor can pay the attorney fees. So if the creditor is going to have to pay the attorney fees, that saves you money, because then your attorneys won't have to charge you by the hour to, file that lawsuit for you, that AP. Now, when you're in a 13, you're going to make a repayment plan to the court. Well, you're paying that attorney to be your attorney for the life of your plan. You need to call the attorney if, for example, you break your leg and you're out of work for 6 weeks and you can't pay your debt of court. If you lose your job or you get a decrease in pay, go see your attorney, because they can file a motion to modify your bankruptcy plan, and you can still keep your assets and not be in the situation you're in. If you were in a 100% plan because you could afford to pay it and then your income's cut in half, you might still be able to keep that car. Don't just give up and not tell the attorney if you have something bad happen to you. That's what the attorney's being paid for, to be your attorney for the life of the 13 plan. They can file a motion to suspend, maybe, so you don't have to pay a payment for a month. They can file a motion to modify. You can get hurt, you can get laid off, you can get divorced. When you go to see your attorney to file the motion to suspend or the motion to modify, they're going to have financial information, such as pay stubs for a couple months, tax returns, maybe proof of whatever your financial situation is that got you where you can't make your Chapter 13 plan payments. Attorney cannot do that over the telephone. Attorney can't modify your bankruptcy case over the telephone. Attorney can't dismiss your bankruptcy case over the telephone. Attorney can't do things without your signature. Let's say you go in Chapter 7 and you want to reaffirm a debt, and then you change your mind. You can't just call the attorney's office and say, hey, I changed my mind. You had to sign papers to make it be the way that you have it set. You have to sign papers to change it. If you don't get in and sign it, your bankruptcy can be dismissed. I guess for now, that's a good summary of the Chapter 7 and 13. More later. Lois Beasley-Carlisle. Take care.